Today we will be going over in detail what your private investigator contract should include and why. Now, you can have an agreement with a simple handshake with another party, and that is technically a legally binding contract. However, it is much more difficult to prove the details of the agreement, or even if the agreement exists, should you need to prove that in a court of law. Most state PI licensing requirements require a written contract to be in place with your clients. One of the first things I need to make clear, folks, I need to make this absolutely clear. I am not an attorney, nor do I play one on TV or on YouTube for that matter. Given that, I cannot give you legal advice, and the contents of this or any other video should not be taken as legal advice. Let's first ask, what is a private investigator contract? Quite simply put, it is a professional services agreement between you or your company and your client. What we will discuss are some of the things that should be in your contract or your agreement to help protect yourself, protect your company, as well as protect your client by clearly spelling out the details of the agreement. This is not an exhaustive list of what can be in a contract by any means. It is merely just the bare minimums that should be in your contract. This video is sponsored by OREP Insurance and Working PI Magazine. OREP is a leading provider of private investigator liability insurance. Visit orep.org for a quote today. First is the header, or the top of the agreement. This should include your business information, your client's business information, and each party's defined roles in the agreement along with the date. Above the header, a name for the agreement can be included as well. For instance, at the very top, Investigative Services Agreement. The next line might read, "This agreement is entered into on this date by and between your company," and your company's address, "herein referred to as investigative consultant," and your client's name and address, herein referred to as client. Note the references investigative consultant and client. Throughout the contract, you should always reference the parties by these referenced names. If you are referencing both parties, you can simply state the parties. Next, you should have a description of the assignment, the investigation, or the work that is to be done. Services to be provided. The parties to this agreement agree that the investigative consultant will provide the following services. You want to have enough detail to explain what you as the professional investigator are going to do, but not so much detail that it limits the overall scope of your investigation. Fees need to be addressed as well in your contract. Now, when I'm talking about fees, I'm talking about retainer fees, hourly fees, or both. Okay, here is a good basic retainer and fee clause for your contract. Client shall place $1,500 in the possession of the investigative consultant to serve as a retainer for this assignment. The hourly rate for all work done is billed at $70 per hour, plus any necessary expenses. Mileage incurred shall be billed at 50 cents per mile. A misrepresentation clause is also very important for your contract. Investigative consultant reserves the right to terminate this agreement at any time if client has misrepresented any information provided to the investigative consultant. An accuracy of information clause for information that you provide to the client is another vital part of your contract. We all use various databases and other methods to gather vital information, evidence, things like that regarding the subject of our investigations. In doing so and reporting these to the client, we need to make sure we clearly let them know that we do not guarantee the accuracy of any of that information. Investigative consultant cannot be held liable for inaccuracies contained in public record information, databases accessed, or other information provided to the client. The next step in your contract is a no guarantee clause. Simply put, we cannot guarantee the outcome of the work provided. We are just finders of the facts, folks, and we just present the evidence as it is presented to us during our investigation. Let's take a look at a sample no guarantee clause. The investigative consultant makes no guarantees as to the success of the investigation, research, or matters in question. A good contract will also have a good indemnification clause. Indemnification of investigative consultant. The client agrees to indemnify and hold the investigative consultant harmless against all claims, damages, losses, expenses, liabilities, and or client or third-party actions arising out of or related to any information which the client provided to the investigative consultant prior to or during the course of services provided. Termination of the agreement is essential in all contracts. Most PI licensing in most states require that a termination clause be in all contracts. This agreement will be in effect for 4 weeks from the date entered into or when all retainer funds have been exhausted. Either party may terminate this agreement at any time with written notice to the other party. Clause covering jurisdiction for legal proceedings is another necessary part. This will clearly define where things are handled in the unfortunate event that something comes up between you and your client. Any legal proceedings initiated by the client towards investigative consultant shall be within your county, your state. Make sure you put your county and your state in the contract, not the client's. Your county, your state. Otherwise, if you have a dispute with your client and they decide to sue you, and let's say they live in New York and you live in California, they will be filing in New York and you will find yourself flying to New York to defend yourself. Signature lines are also necessary for any good contract. This is fairly self-explanatory and it should be kept simple as well. Just have a line for the client to sign and print their name and enter the date. As well, a line for you to sign and date. Now that you have your contract all ready for your client, make sure that they understand it all. Folks, that is not just emailing it to them and then asking, did you understand everything in the contract? Do you have any questions? I usually go over section by section with the client, either in person or on the phone, explaining what each section means. Is that required? Nope. It's absolutely not. But it goes a long way to obtaining confidence with your client and ensuring that you can answer any questions they may have during the early process of hiring you and ensure that there's less confusion down the road with their expectations. Remember, this is a difficult and a trying situation for most clients. Something tragic has happened or is happening in their life, and they could be spending their last few dollars to hire you to get to the bottom of it for them. Also, you are the legal expert in these agreements. Even though you should not ever be trying to give legal advice to your clients, it is incumbent upon you to ensure your contract is clearly understood by your clients. I do this quite simply like this. Mr. Client, let's go over each of the sections of the contract so I can ensure that there's no mistakes. Then I discuss in summary each section from front to back, asking after each section is covered if they have questions about that section.